I am Rosita Jacobi, Assistant Program Co-Chair of the Beverly Hills Bar Association's Trust and Estate Law section. The Trust and Estate section is sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, Pickford Escrow Company, and the Sanborn team. I'm delighted to introduce our speaker, Cynthia Cox. Cynthia Cox is the founder of the Cox Law Group. Cynthia advises clients on conservatorship, public benefit programs such as SSI and Medi-Cal, and planning for elderly individuals and those with special needs. She also frequently consults with other elder law attorneys on special needs and disability matters. Cynthia is a certified elder law attorney through the National Elder Law Foundation and a professor of elder law at Loyola Law School. She's a member of the Council of Advanced Practitioners through the National Academy of Elder Law Attorneys, one of only 10 such members in California. And now let's get started.
Thank you, everyone. And thank you so much for joining our webinar today. I'm really excited to be here to talk to you about California conservatorship. It's one of my favorite areas of practice. It's kind of a love-hate relationship, as I'm sure all of you are aware who are also acting in these spaces and representing people on perhaps both sides of the conservatorship. The developments in conservatorship are very exciting. They're ever-changing. And we're going to talk in just a moment about how conservatorships are generally becoming more and more disfavored. But there's been some backlash to this as well. So just being aware of this can make this a very interesting area of practice. For example, there is some legislation that's pending right now called the Veterans Care Protection Act, which is a draft bill that allows the VA to put veterans under conservatorship. So NALA has joined with, NALA is the National Academy of Elder Law Attorneys, has joined with the Consortium for Constituents with Disabilities. I'm just giving everybody a background thing here. To authorize the U.S. Department of Veterans Affairs to initiate a conservatorship or guardianship proceeding in state court for certain veterans whom the VA determines need a guardianship because they need placement or they can't manage their own benefits. And it will control where the veteran lives, control of their finances, and fundamental civil rights, and gives the VA standing in state court. So this is really a major piece of legislation and a very concerning piece of legislation with loss of civil rights, using basically a placement tool for involuntary institutionalization. And as usual, it fails to address the root causes the reasons we're having these problems, such as lack of supportive housing, insufficient mental health services, and obviously these systems where you can do conservatorship more easily obviously is going to conflict with our less restrictive alternatives. So with that long introduction, we'll look at the agenda items and what we're going to look at today. So we'll go through an overview of conservatorship, mostly from the standpoint of these policy decisions rather than the legalities of how you establish a conservatorship. So we're going to be looking more philosophically at the impact of ageism and ableism on conservatorship decisions. We'll explain a little bit about that. We'll talk about the statutory and judicial requirements for conservatorship, as well as some oversight, misuses, and practical challenges once you're in that conservatorship space. We're going to talk quite a bit about supported decision making as an alternative to conservatorship. and a little bit more about that supporter and what their eligibility is when they are supporting an adult making decisions, what their duties are, and what is required in an SDM, which is the supported decision-making agreement. We're going to look at some practical considerations and other alternatives to conservatorship, including supported decision-making and other alternatives. And we're going to talk quite a bit about family dynamics, conflicts, and court considerations, because if we really want to minimize or get rid of how many conservatorship cases we have to look at what's really bringing those cases into the court system, so that we can fashion some practicality. So next slide. Okay, so overview of conservatorship. Go ahead. So when you're understanding conservatorship, you're probably well aware that it is a court-appointed arrangement for managing the affairs of an adult needing protection. In some jurisdictions throughout the country, they're more general, all-inclusive sort of arrangements. But in California, we're very specific as to our arrangements, and we're very specific as to the orders that come out of those arrangements. They can be extremely tailored arrangements. We have a growing amount of scrutiny nationally and also in California, and quite a bit of criticism, concerns over civil rights, due process violations in conservatorships. And there's been a lot of advocacy groups pushing for less restrictive alternatives that preserve more autonomy and protect folks that have disabilities, as also agedness. Next slide. So the ACLU has been extremely involved in this process. And if you read some of the ACLU's information about conservatorships, it is very far to the point of not wanting conservatorships to be an available alternative whatsoever. What they're touting as part of the problem is that we have an overuse of conservatorships, that conservatorships are kind of a go-to familiar place, but it's often imposed without exploring less restrictive alternatives first. And again, this is a nationwide sort of problem. It does violate self-determination because it can infringe on an individual's rights to make decisions for themselves. And it conflicts with the rules under the American Disabilities Act. It unnecessarily segregates and restricts people. And many conservatorships really lack clear procedures for restoring those rights and ensuring some fairness. And we're going to talk a little bit about the Britney Spears case, because it was so pivotal in California, and now it's really having a national implication, and people are looking at how that conservatorship played out and some of those allegations there to see why did California pivot its laws, and what other people nationwide can start to be thinking about towards making sure that people's civil rights are not infringed upon. So next. So California, coming out of Britney Spears and other high-profile cases, had a dramatic shift towards autonomy. So we had a conservatorship reform law that came out of that, which was a law that mandated courts to really explore these more least restrictive alternatives. So there's always a balance between autonomy and protection. Persons with capacity are allowed to self-neglect. So short of self-harm, adults are presumed to have capacity. And so if you think about some of these cases that people may have brought you over the years, my child has a substance abuse problem and I need them conserved immediately. Or my husband has a gambling problem and he needs to be conserved immediately. But adults that have capacity have a right to make bad, unsafe, and irrational decisions, just like all of us. And indebtedness, that's another one where people can become quite indebted. That's not an indicia of incapacity, just very bad judgment. It can be an indicia of incapacity coupled with other things, but the court in general cannot substitute its judgment simply because the decision appears to be harmful or unwise. Incapacity is often very hard to prove. It's an expensive proposition for families attempting to bring protection to their loved one. And as some of you may have experienced, alleging and proving undue influence can be even worse. And there is really a lack of understanding in general about the differences between capacity and undue influence, and how one can actually have capacity and still be subject to undue influence and still be under those things. So what would be a viable shift? Supported decision making is a legally recognized standard, and for the first time in California, it's supporting greater autonomy as an alternative to conservatorship. So disability rights advocacy and high-profile conservatorship cases have really raised awareness and have influenced a lot of legislative change in these areas. Next slide. We're going to think about some philosophical discussions about ageism and ableism on conservatorship decisions. This in and of itself would be an hour-long presentation. So we're going to just touch on some of this just so that people are aware of some of these biases. Next slide. So ageism has a lot of effect on legal outcomes for older adults. There's a bias certainly in our society that old people are unable to manage their affairs. And what do we even mean by old people, right? That's very interesting. Aging is linked in our culture to decline and failure rather than perhaps wisdom and reverence, as you see in some other cultures. When I adopted my daughter from China, for example, and I went to mainland China, was there for 3 weeks, the person that I was with had gray hair. And so without exception, everyone who was younger than that and didn't have gray hair was bowing and very reverential to the person that was with me that had gray hair. And it just, it showed that there was certainly a cultural difference in how people look at aged people. I've noticed also in my practice that sometimes people with geriatric diagnoses, such as dementia, are sometimes placed in psychiatric situations due to ignorance related to a dementia diagnosis. So there are over 100 causes of dementia, some of which are medical and temporary and driven by adverse reactions to medications and so on. So it may also be helpful to think of senility or dementia or some of those more old-fashioned words as more like a spectrum disorder. And I think that it's best for us all to focus on what a person can do, again, focusing on personhood, competently, rather than the negative of what cannot be performed. So when we're trying to preserve these functionalities, a decline is going to be potentially accelerated by taking away too many things too quickly. I find this often with the children of senior parents when they'll come in and they'll say, "Oh, mom, give that to me. I can do that much faster." It's important to let mom try to work the phone, try to use the phone. Even though it may be exasperating and you may be in quite a big hurry, it's better for the person to continue to use their brain, continue to learn new things, and increase that functionality. Um, the more you take away, the more someone sits sedentary or in front of the television, the more decline you're going to see. And I see that with my own mother who had a stroke recently. And if she sits in front of the television a little too much, her short-term memory just goes to pieces. Whereas if my brother's over there engaging her, they're going out to eat, they're going on walks, she can track things much more readily. And you can't even hardly tell that she has a memory impairment. So just thinking through those things and how you would like to age as well, I think is very important. Judges and attorneys often assume that older age means incapacity as a matter of course, even when supported management is possible. So I've seen people 97 who are sharper than I am, 100 years old who are sharper than I am. So we can't make those assumptions without being exceedingly unfair to the person that you're making those assumptions about. And the court will frequently impose total conservatorships unnecessarily just because someone is aged. And when you combine that bias against ages, with ageism, combine it with racism, sexism, or ableism, then it's going to further marginalize older adults and limit their support access. Next slide. Ableism, likewise, is a presumption of incapacity against someone who has a disability. And this we see quite often when I'm representing someone in a special needs trust and a sort of situation, and a personal injury attorney will call, for example, and say, I have someone who's on SSI and Medi-Cal, and we have to have a special needs trust. And we need a conservatorship so that we can get the funding properly done. And I start to really dig into the situation and realize that the person has complete capacity, but because they were physically limited, everyone in the situation presumed that that person was intellectually limited. So again, we are required to presume capacity under our probate code. Some benefits have presumptive disability attached to them, like there's Social Security disability that will apply to someone. And just realizing that just because someone has been adjudged disabled by Social Security, that only means that that person cannot sustain substantial gainful activity. That person can't be employed on on enough of a full-time basis. And so that person is presumptively disabled. It has nothing to do with cognitive ability, though. So we have to try to not put on these labels, avoid these stereotypes, and just bear in mind that those things may be happening. Next slide. Again, for older adults, it's going to be easier to apply restrictive conservatorships, which are familiar to the courts, rather than exploring new alternatives like supported decision-making. I see supported decision-making rarely applied with older adults with some sort of cognitive decline. And I think that that is an area where we can really start to look at how do we apply supported decision-making in the aged environment, because most of the time it's in the environment where someone has a disability, usually a developmental disability. And so if you are really looking at what a person can do and what a person is having concerns doing, then perhaps that person in those areas of concerns can enlist a supporter and can fill in the gaps such that a conservatorship may not be necessary. Next slide. Now we're going to talk a little bit about statutory and judicial requirements for conservatorship. Next slide. So again, we need to think about California law mandating the least restrictive alternatives. Again, California law discourages conservatorships unless there's no less restrictive alternative that can meet the person's needs. So the statutory requirements under Probate Code 1800.3 mandates that the court consider all less restrictive alternatives before imposing a conservatorship. And it states that a conservatorship should only be imposed and provide care only when necessary. And so the probate code really looks at a task-specific analysis, and that task-specific analysis has to look at what the person is able to do and what the person is not able to do. So often in my conservatorship practice, we'll have a situation where someone has been taken advantage of, for example. Right around Valentine's Day, there's a lot of romance scams, right? And so I don't know if you've had experience with people who've had romance scams, but it can be exceedingly convincing. And a person will send a message to someone on an older adult dating app or whatever it might be. They send a picture of themselves, which is basically taken off the internet. And they say, hey, I'm a veteran. That's always a good line. I'm a veteran and I saw your picture and you look amazing. And I would just like to enter into conversation with you because I'm lonely. And then from there, it grows and grows until the person is stuffing $100 bills into a teddy bear and sending them off to New York City or whatever the situation might be for that particular situation. So if you look at those kinds of things and you say, well, perhaps a conservatorship is required over this area of finance, but the person can certainly continue to make all decisions related to housing and to ability to authorize medication and perhaps manage their own checking account and have some autonomy there, or have a card that is monitored by the conservator that allows economic autonomy. And just to think about those things and have a balance. That's really, really important. Next slide. So again, looking at all of these trends, the courts are looking more and more for evidence of failed alternatives. So they want us to demonstrate efforts that decision-making, supported decision-making in particular, has been tried and failed, sometimes tried multiple times and failed. And so there's proof that's needed that conservatorship is truly the least restrictive alternative and the least intrusive option. This shows respect for autonomy. It shows respect for the person's self-determination. It doesn't violate civil rights and so forth and so on. And what I've also noticed is that even when someone is under conservatorship, based on a lot of those legislative changes that were made coming out of the Britney Spears case and other cases, when someone is even under a conservatorship, that person's wishes are taken into account. So for example, if that person wants their conservatorship terminated, then they can petition for that to happen. That person is entitled to a right to their own counsel and to hire independent private counsel. We've seen cases where, for example, the conservator wished to remodel the conservatee's residence, and the conservatee wasn't living there anymore, wasn't necessarily expected to return, but the conservatee really wanted to weigh in on the design, because if they did come back, they maybe didn't want gray carpet in their living room, right? They didn't want it to be like a rental. They wanted it to be their home. So that conservatee was allowed a tremendous amount of autonomy weighing into the decision making. And I think we are definitely going much more towards this. All of this, by the way, you need to warn your folks that you're representing when you're trying to establish a conservatorship, results in a lot more expense, but it's expense at the because we want to respect autonomy, respect self-determination, and so forth. So we have decided as a state that that's a good trade-off. What if we have a situation, though, and there's always a way of playing devil's advocate here, where there's an undue influencer or a suspected abuser, and the conservatee, for example, wishes to change their estate plan to disinherit their family and benefit the suspected abuser, or allow that person to help making decisions. It takes years for these cases to come to trial and to establish that the suspected abuser is really an abuser, right? And so, and that influence that's being wielded is truly undue influence. So not all influence is created equal. There can be a good child or a good influencer who's telling the individual, you really should be doing this because it benefits you, it protects you. That's not necessarily undue influence, right? So the documentation that you're going to need is showing that the conservatorship is the least restrictive alternative. And the conservatorship documents that you have to file are very good at fleshing that out. They're going to ask you, have you tried this? Have you tried that? And you have to honestly look at whether those things have been tried before you even get to filing the conservatorship. And even when a conservatorship is granted, again, the conservatorship is going to encourage preserving as many rights and as much autonomy for the conservatee as possible. Next slide. Recognizing that there's a loss of fundamental rights associated with conservatorship is very important. So conservatorship can remove the individual's right to make their own medical decisions, for heaven's sakes, to impact their own personal autonomy in that way, which is a core constitutional right, may lose their right to decide where to live, limiting personal freedom, may restrict the ability to manage personal finances, affecting financial independence, may also even limit the right to marry or contract or vote, restricting basic civil liberties. It can result in someone being put in a locked facility if there's a diagnosis of dementia, for example. So that can be very alarming and should be alarming. Next slide. So what is happening also related to challenges in the conservatorship arena, talking about oversight and misuse and practical challenges. Next slide. Conservatorships, once established, can result in a variety of ills. So there can be a misuse of authority that can prolong a conservatorship. This was alleged in the Britney Spears case, self-enrichment, and then due to court overload, lack of oversight sometimes. We all know that our Los Angeles court system is dramatically overburdened at the moment. And this coupled with the fact that conservators themselves might be quite inexperienced, such as a family member that's trying to act for the first time and doesn't understand complex accountings and so forth. Or if it's a professional fiduciary, sometimes our professional fiduciaries are extremely overloaded and may not have their own business system where oversight and management is in place properly to be able to self-monitor. Next slide. As we said, the courts are very overburdened right now. Court investigators face an extremely heavy workload, causing a lot of delays in the required reviews. And the investigators are now required to really look into possible alternatives and what the conservatee wishes, and so on. Again, the accountings are often incomplete and difficult for families to understand, and difficult if there's a family member who's trying to challenge an accounting effectively. It can be difficult to understand the numbers in the way that the numbers are presented. And these other items we already discussed. Next slide. So let's talk a little bit about supported decision-making since it's the new kid on the block. Next slide. So supported decision-making allows the adult to make a decision with support. It's recognized in California law, and it validates the individual and an individual's ability to make choices. Courts must now consider it as an alternative to conservatorship, and it enables a person to retain their legal rights and self-determination, unlike conservatorships. So the idea of supported decision-making is that you are going to be providing assistance if you are a decision supporter instead of substituting your own decision-making. So the terminology they use is adult. So the adult is the person who's seeking support, and the supporter is the person who's supporting that decision-making. The adult is always making the decisions himself or herself, themselves, right? So it promotes individual empowerment in that way. When there have been concerns raised about whether you are acting as a fiduciary under the supported decision-making process, the answer has seemingly been resoundingly no if you're a supporter, because you're not making the decision. You are simply lining out options, lining out alternatives, gathering facts, discussing, and so forth. So supported decision-making aligns with the ADA and its mandates, and it supports integration and individual rights. And courts, again, are going to consider these alternatives, and court-appointed counsel must look into this also. All of the counsel must discuss these options when someone comes into you seeking a conservatorship. This is the first thing that you should be exploring, is whether this would be a possibility. Next slide. So as you can see, there have been a number of reforms that came primarily out of the Britney Spears case, with Assembly Bill 1663 being the supported decision-making bill. Next slide. So defining supported decision-making, what is happening under this is the person is making an independent decision, but with support. So it sounds a little bit like an oxymoron, I know, but the scope of the decision is up to the adult, and it can include medical, financial, housing, education, social, religious, or legal matters. So the ADA actually has some really helpful templates that have a very simple kind of questionnaire. And the questionnaire says, medical decisions. I can make these decisions myself. I can make these decisions with support. And I need help making these decisions all the time. And I don't feel I can make this decision. So a person can actually choose how they feel about what they can do on that spectrum. So, and the same for financial and housing and education. Once that is complete, then one can sit down with the supporter and come to an agreement. And I've been party to a number of these supported decision-making agreements where each person is represented by separate counsel, and an agreement is actually drafted and executed. It's completely voluntary. It does not and it cannot imply incapacity, and the adult retains full legal decision-making authority. Next slide. So, of course, we have some concerns about these supporters. Who are these supporters, and can this person be a bad actor? Next slide. So as you can see, the eligibility of the supporter, they must be chosen by the adult, and they must comply with disability protection laws. And so there's a number of things that can disqualify a supporter. A supporter can be disqualified if they're under a restraining order, liable for any sort of abuse, if they've been removed as a conservator, or if there's allegations of elder or dependent adult abuse. Supporters must respect the adult's values. So what does that mean? Once in a while, you'll have someone that comes along that has an extremely strong personality and really would just like to run the show right over the adult's head, right? And so that's possibly not the best supporter, because if you have someone who is supporting, they have to be in a beta role instead of an alpha role. They have to respect that person's values. They have to maintain confidentiality, act honestly and diligently in good faith, and so on. And they cannot make decisions, sign documents, or substitute their judgment unless that person is legally authorized to do so. Next slide. So what is required in an agreement? A supported decision-making agreement has some required components under the law. And so the required components are that the supported decision-making agreement must be in very plain language. It must list all of the support areas that the person desires. It must have a certain amount of disclosures and signature of the adult and the supporters. It has to be before two disinterested witnesses or a notary to be valid, and the agreement can be terminated by the adult or the supporter at any time upon death or by destroying the agreement. And if you want to know where this law is located, I did do an appendix that has all of Assembly Bill 1663, all of the changed California codes, which codes were changed, and the summary of the impact. I'm sure that'll be helpful if you're looking for that. Next slide. So let's look at some practical considerations and a few more alternatives to conservatorships. Next slide. So practical takeaways and challenges under supported decision making. Again, this the fact that it's legally recognized and supports capacity without delegating authority is a very good thing for the person who is the adult. However, it can have some real practical challenges because third parties can ignore these agreements entirely. So you can imagine if you take this supported decision-making agreement to a bank and say, I'm trying to get some information to help my sister make some decisions. Can you please provide me with her banking information? Absent a power of attorney or a conservatorship or something else that the bank understands and is going to recognize, you're probably not going to get very far. Further, if you have to make a very quick decision, this is a slow process because what you're required to do under supported decision making is to lay out all of the information and all of the options for a person to be able to make a decision. And so that in and of itself is going to slow down the decision making process. And sometimes a decision has to be made very quickly to avoid financial loss and some other things. So that's a consideration. There might be a potential conflict of interest. So if you've named a supporter, for example, who's also the downstream beneficiary of your estate, they may not be in favor of you spending money for these various purposes and may try to influence you to do something different. So conflicts of interest are to be avoided, but a lot of the time the supporters by definition already have a conflict of interest. The attorney role in ethics is very interesting in this space because the attorneys have to balance attorney-client privilege and vet supporters and also include the chosen team in the decision-making process. This is part of the law if you look at it. So it says, unless the attorney believes that this person is a suspected abuser or otherwise disqualified, you have to figure out how we're going to vet that particular thing. Then the attorney must, and it's mandatory, include the chosen team in the meetings and in the discussions. So thinking about how that's going to impact attorney-client privilege, how we're supposed to vet supporters, and who we're going to include if they're wielding too much influence. Do we have the power to ask the adult to exclude that supporter? There's all kinds of implications that can come up in these spaces. Supported decision-making does work well, though, for intellectual developmental disability communities as a less restrictive alternative. Been really great in that space. Next slide. As we're running kind of short on time, I'm just going to go over this quickly because I'm sure that you're aware that if you have estate planning in place, that can be a less restrictive alternative. So why do you need to have the court manage finances if you have a trust and you have powers of attorney and you have healthcare directives in place? Why do you need the court to help with medical issues? Or we can use special tools like special needs trusts or CalAble accounts to provide financial management, benefits protection, and things like that. Next slide. in the space of conservatorship, you're always going to be looking at balancing autonomy and safety. So autonomy and safety requires choosing options that empower adults to live as independently as possible, yet we're trying to get some level of security. You're not going to have a perfect world. No one has a perfect world where they're completely safe, no matter what. But the goal is to minimize the harm as much as possible while maximizing independence and personal empowerment as much as possible. And the advocacy principle that comes out of persons with disabilities, nothing about me without me. What that means is these secret conversations where people are going off to the side and saying, hey, I really need to tell you some things about my brother. He really needs help in these areas, but I don't really want you to tell him that I brought that up. Those kinds of things really are not respectful of the individual and their ability to actively participate in decisions that really are core to their own lives and affect their own lives and their own care and their own autonomy. So just bearing that in mind, nothing about me without me. Next slide. Family dynamics, conflicts, and court considerations. We're going to talk a little bit about why we end up in conservatorship anyway. Next slide. So when are conservatorships really necessary? So I have to say that I disagree with the theory that conservatorships are never necessary and there has to be something better that we can do, and all conservatorships should be taken off the books and defeated. When someone is truly unable to meet their needs or make safe decisions, then it seems to me that a conservatorship just has to be necessary. We have to try and preserve rights, preserve assets so that that person can be taken care of. And when someone is really being abused, if someone is in the midst of having elder abuse leveled against them, physical or financial, or undue influence is being wielded where there's rapid asset loss and financial exploitation by individuals that person trusts, a conservatorship may be one's only option. Often, family conflicts trigger conservatorships more often than not. And this is an area where perhaps there can be some discussion about some real viable alternatives. So disagreements about how a relative is caring for an elderly person or a person with disability can escalate conservatorships to resolve disputes, usually over control or over isolation. Lack of transparency makes people worried about what's really going on in the home, and so forth and so on. So that really does become a very frequent trigger, as well as fostering a lot of litigation around the conservatee, and can be extremely harmful. Sometimes it gets to the level where the family conflict is going to really start harming the elder, and a neutral professional conservator is often appointed to provide unbiased care and management. Next slide. So the court is really going to look at this, and if someone is applying to be a conservator in one of these situations where there's a lot of family conflict, they're going to prioritize individuals who can cooperate with relatives and share information, de-escalate family conflicts effectively over folks who are continuing isolation, who are saying, my brother doesn't have any right to that information. I'm not going to give it to him because he's just going to fight with me, or whatever the situation might be. So we're going to always be looking to preference to those people who have been in a position of providing care for some time and are the closest, most supportive relationships, rather than people who come in and are talking mostly about finances, less about the focus on the person whom we're trying to help. So they'll also look at who's been managing the finances responsibly, and also looking at people who are not managing finances responsibly, and that person is probably not going to be appointable. They're also looking at neutrality and a lack of self-interest as key traits to avoid conflicts of interest in conservatorship appointments. Next slide. So here are some of the warning signs that you'll see if it's a conflict-driven conservatorship petition. You'll see disputes over spending, someone who dislikes the person acting as a caregiver or dislikes the caregiver that person has had in place. Sibling accusations back and forth will sometimes indicate this. And sometimes people are not talking a lot about incapacity. They're mostly talking about, my brother did this, my sister did that, my sister's always done this, my brother's always done that, or whatever the situation might be, which shows that this is not really so much about mom and dad or about the person with a disability. This is, vying for control and those sorts of things. Isolation tactics you'll often see in these sorts of things too. Blocking visits, controlling visits inordinately. You have to give me a week's notice if you're going to come over and visit. Controlling communications that isolate the elder. And it can be very insidious. So you can isolate an elder or a person with disabilities simply by taking their glasses and putting them just out of reach and saying, oh, you don't need those, Dad. Let me read this for you, or whatever the situation might be. So just watching for those things. Petitioners may also seek a conservatorship to control the inheritance or property if there isn't a good alternative, or if they don't like the way that a sibling is controlling the property, or so on. And elders who are going to object to this or function well with support are going to have to suggest very strongly through counsel and otherwise that a conservatorship in these sorts of situations is simply unnecessary. Next slide. Okay, so again, we've summarized the changes to AB 1663 in the table that's attached to your outline. It talks a lot about less restrictive alternatives, about new documents that are necessary, preferring conservatee choices, and allowing easier termination and review. A big component is the recognition of supported decision-making, and regional centers were restricted from serving as conservators under the new legislation. There was a number of new rules that came into play for professional fiduciaries as well. Next slide. So again, in conclusion, we looked at the complexities of conservatorship, which involve a lot of challenges related to civil rights concerns, ageism, ableism, impacting decision-making and autonomy. We looked at supported decision-making, and it offers a promising alternative that enhances individual autonomy in conservatorship frameworks. I want you to take it a step further, though, and say, even if supported decision-making is not appropriate, let's really look at our conservatorship orders that are coming out of this and tailoring it so that the individual that is going to be continuing to operate under this conservatorship as the conservatee has as much ability as they can possibly handle on their own to avoid degradation. And then we're always looking at balancing safety versus freedom. So if we can get effective family involvement, some practical tools to help balance that safety with personal freedom and decision making, then possibly we'll come a lot closer to really cutting down on the conservatorships that are having to be filed in our court systems that are already overburdened. Next slide. Okay, thank you very much for your attention. I'll give a shout out to Rena Shaw, my associate, who also helped me with these materials. Thank you very much, Rena. And we have a question and answer place that you can post questions. And let me see. The first one says, has anyone succeeded in moving an individual within a limited conservatorship, developed a DD, to a self-decision mode, essentially less court oversight? No, I have not moved someone, but I have not tried. And I do think that it would be absolutely a possibility. So I think what I would do in order to try and get that done is to try the self-decision mode in tandem with the conservatorship. And if you do a trial run, seems to be working well, then petition to terminate the conservatorship and see what happens. Can you explain how mental health decisions are treated when someone is conserved? That is an interesting question. Mental health decisions are under a complete different type of conservatorship in California. It's known as an LPS conservatorship. A normal, regular old everyday attorney cannot start an LPS conservatorship. It has to be started through, in general, through a psychiatrist on some type of referral. So usually a 5150 hold or something like that. And then one goes into an LPS situation. So that LPS situation then can become a 14-day hold into from 72 hours into a 14-day hold, and then referred for conservatorship. Public guardian is usually appointed, and then a family member can step in. If someone has mental health decisions that don't rise to the level of gravely disabled, sometimes it can be dovetailed into a general conservatorship, but you always have this situation of you might end up in a 5150 and you might end up with both conservatorships happening at the same time. LPS conservatorship is considered to be quasi-criminal. It only lasts for a year. The person has and then it can potentially be renewed. The person has a public defender that's in defending, and it's a completely separate courthouse. So it's a very separate system, and we have some wonderful mental health attorneys who operate exclusively in that space, and some that operate in both spaces. So that would certainly be where I would go there. Care court as an alternative to conservatorship. Care court is a very interesting alternative. It's basically a voluntary alternative. It's narrowly drawn, and it's for folks who have substance abuse issues. And so that person can voluntarily go and say, I'm going to get treatment. I'm going to have this structure and this sort of check-in system as an alternative to conservatorship. 100% voluntary. Again, it's kind of outside the scope, but John, if you want to talk more, I have tons of materials on care court. I find it to be very, very fascinating. There are some people who are very concerned that people might not be understanding that there are civil rights limitations related to that, but it is very interesting. If Next, whoop, where did it go? I lost it. If I take over a special needs trust already established, should I give notice to SSA and Medi-Cal, even though notice has already been given? The answer is yes, you should always give notice. And I'm assuming you're taking over as the attorney representing the same trustee. I don't know. I take that back. If you're just the attorney representing the trustee, then once the notice has been given, if a copy of the trust has already been given to that person, the SSA and Medi-Cal, then I wouldn't think it would be necessary again. If you're taking over as a new trustee, it's definitely going to be required under 16061 normal noticing. If you're before the court, the notice will be required every time you do accountings and so forth and so on. What is my approach with dealing with GALs or CACs who are clearly wrong about certain items or just a problem in general? Wow, we have some of this as well. You always want to treat people with civility and with respect because you never know whether they're going to be on the next case that you're involved with, and try to treat people that have a divergent opinion as respectfully as possible. If you have a CAC that is adverse, that could be expected because they have to take the position of the conservatee, which might just be not in keeping with what you're trying to get. And you may want to go in and try to get a GAL appointed. If you have someone who's completely off the rails and attacking your person unnecessarily, I have had one time in 32 years where I sought to remove a CAC from the case, and that was successful, but that was really exceedingly unusual circumstances. What if a conservatee has mental issues and won't see a doctor? Can't do LPS. How likely will you be successful in a probate conservatorship? Any tips? This is one of the most difficult situations because if the court-appointed counsel is also fighting your ability to get any sort of doctor's declaration, you might be able to get a temporary conservatorship in place because you don't necessarily need a capacity declaration in order to provide temporary support. However, the conservatee having mental issues won't see a doctor. That can also be indicia that a conservatorship is necessary. And I think there's some old case law on point there. Sooner or later, you're going to be looking for the court to hopefully put a 730 expert in to be able to do that assessment because the court will not be able to go forward without some sort of assessment. Sometimes you can talk the conservatee into doing it either through the guardian ad litem or through CAC, simply because they think they have plenty of capacity. So all you have to say is, please prove it. And sometimes you can get it done that way, but that is an extremely, extremely difficult situation. Individual with schizophrenia leads a very crummy life, presents well in court, conservatorship denied. Oh, National Shattering Silence Coalition is screaming for legislative action, and SB 403 failed to advance. All right, John, talk to me later because these mental health issues are really, really tough. And just because someone has schizophrenia does not mean that conservatorship is warranted. And sometimes it just breaks the heart of the people who are trying to protect that person. But protection may or may not be available because you may not really have gravely disabled, you may not have an incapacity, and other things. Are long-term LPS conservatorships subject to the new least restrictive standard? It's a completely different system. I would assume that all conservatorship is subject to the least restrictive standard, but once you're already in that system where someone is in a 5150 hold, if that person is not simply released, which by the way, a lot of people are simply released. And unless you go on an extreme letter writing campaign to the psychiatrist, because you're not going to be able to talk to this person, and the loved one is in lockdown, right? So unless you're able to really speak to that by tons of letter writing, your person may be gravely disabled and simply released by the psychiatrist. Happens all the time. And then they bounce back into the system and they're simply released again. So this is where you really need to talk to one of these mental health folks. And I will right now at least take the moment to say what my email is so that if you want to reach out to me, I can give you a little more information about it. It's kind of a long email. It's Cynthia, spelled traditionally CYNTHIA, at coxlawgroupinc.com. COXLAWGROUPINC.com. And she put it in the chat as well. Thank you so much, Susie. Okay, I am a fiduciary who's going to manage a trust from now on. You poor thing. That is the hardest job on earth. Bless you. That's crazy. Oh, thank you very much. Someone just said thank you. Who makes the decisions on behalf of a dependent adult whose parents have never sought a conservatorship? If the dependent adult remains residing with the parent, does the parent automatically assume rights? The answer is absolutely no. Once the child in this situation turns 18, they are presumed to have their own abilities and their own decision-making authority. So what you will often see is people will start to look towards that 18-year-old related to medical decisions, kicking parents out of discussions on health that they've always been in. Sometimes it happens, sometimes it doesn't, but it's what the law requires is that 18-year-old has the ability to make decisions for themselves. So at that point in time, a lot of people in the developmental disability space either look to supported decision-making and HIPAA waivers, powers of attorney for financial matters and healthcare, if that's appropriate, or they petition for conservatorship. So let's see, it says, does the parent automatically assume? Yeah, so that one, it had another nuance that basically said, should we seek conservatorship over the parents? And, that is a possibility. Do you have experience with contested conservatorships by regional center? Yes, I had one long trial with regional center one time. It was a lot of fun. You can definitely talk to me off line, and I'll give you all of the rundown of how that went. I do have a good checklist for supported decision-making agreement. It comes from several different sources. I know ARC has a lot of information on supported decision-making, ARC. NALA will have some information on that too. But John, if you want to reach out to me, I can do that. Yes, and I think we already answered this one on whether the least restrictive standard applies to LPS conservatorships. But again, it's not my area of expertise, so I would certainly reach out to me if you don't have a mental health sort of background, and maybe we can get someone with more expertise to help. Okay, I think I have answered all of the questions, and I can't tell you how much I appreciate your attention this afternoon. I am available if you need anything further, and thank you very much.